Thanks, Maynard. Welcome, everyone, to the final webinar in our series on lessons from case law. Today we're dealing with legal requirements for website accessibility. My name is Caleb Berkemeyer. I'm the training specialist here at the Mid-Atlantic ADA Center, which is a grant-funded project of Transcend, Inc. And I'm going to introduce our speaker for today, Rachel Weisberg. Before I do that, I just want to say briefly, and I'm sure that Rachel will mention this as well, that we're not going to be covering how to make your website accessible today. We're just talking about legal requirements for accessible websites. So Rachel Weisberg is a staff attorney at Equip for Equality, where she has represented hundreds of clients in individual and systemic disability discrimination cases under Titles 1, 2, and 3 of the ADA and analogous state and local laws. Rachel enjoys providing in-depth client counseling services as well as direct advocacy services in administrative and judicial forums. Rachel also manages Equip for Equality's Employment Rights Helpline, which aims to expand employment opportunities by providing legal and practical advice to applicants and individuals with disabilities. Rachel is a frequent trainer on the disability rights laws and speaks regularly at national conferences and on webinars. Prior to Equip for Equality, Rachel worked for the Civil and Disability Rights Bureau of the Illinois Attorney General's Office and as a law clerk for Chief Judge James G. Carr in the Northern District of Ohio. Before law school, Rachel was an information specialist for us here at the Mid-Atlantic ADA Center, and we're pleased to have her back for this final part of this series. Rachel, I'll turn it over to you.
Okay, hi. Thanks so much, Caleb and Maynard. Caleb, I'm hearing a little bit of echo. I just want to make sure that folks on the line aren't hearing that too. Actually, I think it went away. Okay, well, hello, everybody, and good morning or good afternoon, depending on where you are. As Caleb said, I did work at the Mid-Atlantic ADA Center before law school, so I'm just really pleased to have had the opportunity to do this three-part series, and really excited about the one we're going to be focusing on today, which are the legal requirements for website accessibility. And this is an area, as you'll see as we talk through some of these cases, where there's a lot that's out there, there's a lot we can all learn from, but it's also an area where there's a lot that's unknown, and there's a lot of things in the works. And so today's session will be a mix of lessons that we know and kind of issues to keep an eye on. So that kind of keeps things fun and exciting. So moving on to slide 14, as Maynard mentioned, there is no CEU credit, but if you are an Illinois attorney, we at Equip for Equality are able to provide 0.75 hours of continuing legal education credit, or CLE credit, for Illinois attorneys. For folks who are attorneys on the phone that are outside of Illinois, we've had some mixed results about whether our certification is acceptable to other jurisdictions. We'd be happy to send you a certification that you participated and you can give it a shot with your state. So if you are an attorney and you are interested in getting CLE credit for today's session, all you need to do is send me an email following today's presentation and just let me know that you participated for the whole thing. Feel free to send your attorney ID number as well. Okay, slide 15. So what are we going to do today? Here's our plan. We are going to start with a refresher on issues of website accessibility. So we'll outline some common barriers, and we'll talk a little bit about the regulations or lack of regulations and guidelines for making a website accessible. As Caleb mentioned, this is not, I am not a website accessibility technical specialist. I'm a lawyer, so this presentation is not going to provide that technical guidance. There are a number of really excellent presentations out there, but if that's what you're looking for today, I just want to be very upfront and clear that that's not what you're going to get. You're going to get the legal perspective today, although we will, again, give some general information just to make sure we're all on the same page. Okay, so after that refresher, we're going to dive in and we're going to talk about some recent cases and settlements, all looking at issues of website accessibility. To highlight and to preview what we're going to do, we're going to talk about whether compliance is required without regulations, and if so, how to comply without regulations. And then we're going to really learn from a lot of great settlement agreements and some court decisions out there, some strategies to ensure long-term success. We'll, of course, want to make sure we focus on the diverse needs of different people with different disabilities, so we'll look at that. And then we'll wrap up today by looking at a little bit beyond our typical website access case. We'll look at issues of kiosks and point-of-sales devices. And then I'm going to at least put a topic in your brain about making sure that your employment practices also consider website accessibility. At the end, I'm going to give you some resources, including resources about how to make conform to those technical requirements, and we'll do a recap of the lessons learned. So that's the plan for the next 40 minutes or so. Okay, moving on to slide 16. So, we're going to spend a lot of time today talking about people who filed a lawsuit because something wasn't accessible. A website wasn't accessible. So, although we're not going to dive into the technical issues, I do think it's important we do a little level setting just so we can kind of understand, well, what does that even mean? Like, what is a barrier to a website? What does that look like for somebody with a disability? So the brief overview, I'm going to give you a couple examples of virtual barriers. One issue that comes up for people who are blind who use screen reading software to access the internet or any sort of website or electronic information is when information is conveyed visually through a graphic or through an image or through a chart. And the reason why is that folks who use screen reading software, the software actually reads the text. But the software, if it gets to an image, it's not smart enough to understand what that image is. And so it can't understand the content that's being communicated. So the way to resolve that issue is that there's a way to add something called an alternative text or an alt text. And what that looks like, there's an image of that on this slide, slide 16. In the top right, we have a green circle that says number 6 alternative text. And so I also have an image underneath there which shows how you would add that alt text to that image. And there you just add the narrative, image of green circle that says number 6 alternative text. And so with that alternative text added, then that content can be communicated and understood through a screen reading software. So that same concept is also why scanned PDFs are not accessible to folks who use screen reading software, because a scanned PDF, if you think about it, is just one large graphic or one large image. And so the technology can't really get in and read the PDF in the way to make that content accessible for folks who use screen reading software. Okay, slide 17. We're going to go through a few more examples. Another issue and a barrier to website and digital accessibility is when content that's on a website isn't organized in a way to help people navigate it effectively. So if you think about how somebody who can look at a screen visually, if there's the same repeated header at the top of every single website, well, we can kind of skim through that and jump to the content. But if you're accessing it through a screen reading software, you want some sort of way to bypass that big block of content so that somebody doesn't have to get that same information each and every page. So really just putting in things like clear titles, section headers as a way to address those types of barriers. Another issue is by websites that require the use of a mouse instead of a keyboard alternative, which of course poses difficulty for folks whose disabilities make it difficult or impossible to use a mouse. Another barrier is when content is displayed that can't be adjusted by font or size or color contrast. So a lot of folks who may have low vision want to be able to enhance or blow up the screen to be able to look at it a little bit larger. Or some people who have learning disabilities like to change the color contrast so that they can that can help them facilitate their reading. Other issues and common barriers are when audio or audio-visual content is communicated through a website without captioning. Well, of course, people who are deaf or hard of hearing aren't going to have equal access or really any access to that type of audio information. Another barrier is that sometimes visual content that's flashing visual content can sometimes trigger seizures for people who have epilepsy or other seizure disorders. And then my final example on in this slide is color contrast. And I have something where it's kind of a medium gray and then with a little bit of a slightly darker gray that says, can you read this? Well, certainly this is not going to be, this is going to be a barrier to accessibility for people who have low vision, people who are colorblind, but this is just a great example of, the concept of universal design. I mean, I don't think this type of color contrast is good for anybody. Anyone who looks at this website is going to have a hard time reading it. And so it's a good reminder that even though oftentimes we're making a website accessible in a certain way for people with disabilities, it often is just good design and good good business sense for all users. Okay, slide 18. So now that we have a little bit of an overview of the type of barriers, the next question is, okay, well, how do we make a website accessible? Well, as many folks on the phone know, in other contexts, we have some guidance from the Access Board or the Department of Justice, and they help define what accessibility means. So when we have questions about how to make a restroom accessible or how to make a doorway accessible, we can often look to the Department of Justice's regulations. We can look to the Access Board's guidance, and it gives us really specific information about that. Well, we thought that was going to be what was going to happen in the world of website accessibility as well. Back in 2010, so almost a decade ago, the Department of Justice initiated the rulemaking process by publishing what's called an advance notice of proposed rulemaking on website accessibility. And they kind of asked a bunch of questions, what standards should we be using? How do we know which website is going to, or what rules are going to apply? And that's usually the first step, and so we were waiting for a while for the next step, which is the notice of proposed rulemaking. And in years went by, but in 2014 and 2015, the department announced some plans to publish this notice of proposed rulemaking. I think both the business community and the disability community were anxiously awaiting that. There were delays and delays and delays and delays, and ultimately in 2017, the Trump administration placed that rulemaking in inactive status, which basically meant that things were going to be paused. And then in December of 2017, they affirmatively withdrew the advance notice of proposed rulemaking. So where does that leave us? Well, it leaves us knowing that we're not going to have regulations from the Department of Justice anytime soon to help us understand what exactly it means to have an accessible website. Moving on to slide 19. But even though we don't have that DOJ guidance, we do have some help, both from the Department of Justice, from other federal agencies, and just basically from industry standard. So there's a set of guidelines called the Web Content Accessibility Guidelines, otherwise known as WCAG. And they were developed by an organization called the Web Accessibility Initiative of the World Wide Web Consortium. This is essentially a group that got together and came up with these voluntary guidelines for how to make a website accessible. And the way that they work is that they've got 12 different guidelines for web access. There's also 3 different levels of success criteria, and so oftentimes you'll hear about WCAG 2.0 level AA. Well, that is essentially the type of success criteria. And WCAG has a couple different versions. So up until middle of last year, we were all talking about WCAG 2.0, which was a version that had been updated in December 2008. And I'm sorry, I got a note to lower my mic. I apologize if I am screaming at everybody. Is that a little bit better, Barbara? Okay. If there's any other issues, please let me know. I do not want to be screaming. And then last year in June, WCAG was updated, and now we have WCAG 2.1. I have a link here, again, for folks who are interested in diving in and learning a little bit more about WCAG. And it is interesting to just kind of scroll through and get a sense for how this is organized. Okay, you heard me say that WCAG is a voluntary guideline, and that's true. But if we look at what other federal agencies have done, they've actually kind of blessed WCAG. So we have Section 508, which is a section of the Rehabilitation Act that applies to federal agencies, and it requires them to have their websites be accessible. And for a while, we have Section 508 guidelines and standards, but They, in effective January 2018, actually they did what's called the Section 508 refresh, and they essentially incorporated WCAG 2.0 into their own standards. And so, no, we don't have the Department of Justice necessarily blessing WCAG, but we do have one federal agency, the Access Board, saying that this is what we're going to look at when we look at website accessibility for federal agencies. We also have the Air Carrier Access Act, which is the law that prohibits discrimination for air carriers and airplanes. And they have, the Department of Transportation has promulgated regulations about website accessibilities for airlines. And they have incorporated WCAG 2.0, and that was effective back in 2016. So we do have these two different agencies that have kind of blessed WCAG 2.0, level AA, which is a helpful tip. Moving on to slide 20. Okay, so let's look at some cases. And the question again is, we've got these no regulations from the Department of Justice, so does that mean that we don't need to comply with the ADA? And hopefully folks paying attention today will assume that the answer is no. And I wanted to talk a little bit about the cases that confirm that. So the lesson that we get from this first case we're going to talk a little bit about is that even though the Department of Justice has not issued regulations, businesses and other Title II and Title III entities are required to comply with the ADA. And this is something that has just been reinforced in a very recent case called Robles versus Domino's Pizza. This may be a case that's familiar to some folks, but what happened here is that we have Mr. Robles, who's an individual who is blind, and he wanted to order a customized pizza from Domino's. And he tried to access it on their website using his JAWS software. Wouldn't work. He tried to access it on his iPhone using his iPhone voice-over program. That didn't work. So he filed a lawsuit under Title III of the ADA in state law. Well, Domino's filed what's called a motion to dismiss, so argued that, that the facts as laid out don't establish an ADA violation. And they made a number of different arguments, but I'm going to focus on two. One argument that Domino's made was that the lawsuit violates due process principles because the ADA and its regulations are silent when it comes to websites, and they're silent about what specific standards should apply. And they argue essentially that it would be unfair to hold Domino's responsible for complying with the ADA or meeting any specific requirements because it's not in the ADA or the regulations. Okay. Domino's also argued that this lawsuit should be stayed or essentially put on hold until the Department of Justice issued its regulations. They invoked this doctrine called the primary jurisdiction doctrine, which essentially says if there's an agency out there that has such expertise in a particular topic, we should let them come up with the standards as opposed to letting the courts figure this out for themselves. Okay, so those are the arguments that Domino's made. Moving on to slide 21. And the first thing that happened is this case was in the district court, the trial court level. And the court actually agreed with Domino's, to the great surprise of a lot of people out there. And they granted the motion to dismiss the case without prejudice, which essentially meant that they bought the argument that Domino's was being forced to essentially comply with a specific standard when they didn't really have any reason to know what that standard was. And the court used this language that they conclude by calling on Congress, the Attorney General, and the Department of Justice to take action to set minimum web accessibility standards for the benefit of the disabled community, those subject to Title III, and the judiciary. So, this kind of set alarm bells going in the disability community and a lot of confusion in the business community about what this really meant. Well, Mr. Robles appealed the case to the Ninth Circuit, and this case got a lot of attention. There were amicus briefs or Friends of the Court briefs filed on both sides, including from the National Federation of the Blind, American Council of the Blind, and many others. So what's interesting is that while this case was pending, we got some information from the DOJ. So moving on to slide 22. So while this case was pending in the Ninth Circuit, the Department of Justice issued a letter making its own kind of opinions about website accessibility. And here's what they said. The DOJ first articulated its interpretation, and I'm quoting here, that the ADA applies to public accommodations websites over 20 years ago, and that this interpretation is consistent with ADA's Title III requirements. Okay, so what does that mean? We now know, or we knew, but DOJ reiterated the fact that yes, the ADA applies to public accommodations websites and that this isn't new. This is something that they've had a consistent position on for over 20 years. Okay, what else did they say? The DOJ says, well, they've consistently taken the position that the absence of a specific regulation does not serve as a basis for noncompliance with the statute's requirements. Okay, that's a really important point for this argument, right? It said, even though we don't have DOJ regulations, that doesn't mean that a public accommodation can just throw its hands up and say, well, I guess that means we don't have to comply. It means that they still have obligations even if they don't have a specific regulation. So that was very important for this case. Okay, what else did this DOJ letter said? Well, it said that public accommodations do have flexibility without the regulations, and that noncompliance with a voluntary technical standard doesn't necessarily show noncompliance with the ADA. Okay, so what's DOJ getting at there? Well, I think that they're getting at WCAG, right? And they're saying, you know, failure to comply with WCAG doesn't necessarily mean an ADA violation, but you still have some ADA requirements even without the DOJ regulations. Okay, so now what else does the letter say? It says that it calls on Congress to provide greater clarity through the legislative process. Okay, so with that kind of position taken, moving to slide 23, we now get the Robles decision in the Ninth Circuit. So what does the Ninth Circuit say? Well, and this was a decision, again, that just came out a couple of months ago. Came out, I believe, in January. And the Ninth Circuit reversed and remanded that lower court decision, and it found for Mr. Robles, it found for the plaintiff, in a few main holdings. One is it said, look, you know, the ADA applies to Domino's website and its app because the ADA requires places of public accommodation like Domino's to provide effective communication. And then they said, you know, it's really irrelevant. It's irrelevant to the question of ADA coverage whether or not Domino's services are being provided through a website or mobile app, or if they're being provided in a place of public accommodation. And they look at this language and they use the words of and in. They say, you know, the ADA applies to services of a place of public accommodation, not just in a place of public accommodation. So some small words being used, but with some really big meaning that the Ninth Circuit found. Moving on to 24. And this is, the Ninth Circuit also found that there was no due process violation. And this is a really important finding, right, without these regulations. But the court found that, you know, Domino's has had fair notice that the ADA applies. The ADA, it's not vague. It's a broad law. It applies to, you know, everything that a place of public accommodation does. And, you know, in addition, the Department of Justice has been clear on its position for over 20 years that the ADA applies to websites. And so, you know, it's kind of not, you can't 20 years later say that they had no idea that this was something that was going to be a requirement. So the court also said, look, if you look at what Mr. Robles, the plaintiff in this case, asked for, he didn't ask that the court find that Domino's violated the law because its website didn't comply with WCAG 2.0. Instead, it just cited WCAG 2.0 as a possible remedy. Okay, it's a little bit nuanced, so I'm just going to say that one more time. They're saying that, you know, he didn't say that Domino's violated the law because the website didn't comply with WCAG. They were just offering WCAG as a possible remedy. And then the court also emphasized, just like DOJ said in this letter, that the lack of regulations doesn't eliminate a statutory requirement. Okay. The third holding that the Ninth Circuit said went back to this primary jurisdiction doctrine. Remember, that was a doctrine that said, you know, if an agency has the expertise, sometimes we should wait and let the agency make this decision. But at this point, when the Ninth Circuit's arguing this or deciding this case, it knew that, you know, the regulations were put on were withdrawn. And so the court concluded that any sort of primary jurisdiction argument would cause an unnecessary delay, and that was inevitable. And the court also explained that, look, you know, they're often asked what constitutes effective communication. This is not a new concept. It's something that courts have to decide all the time, and so they are perfectly capable of making that sort of decision, even in the absence of DOJ regulations. So my caveat, because as a lawyer I can't talk about a case without a little bit of a caveat, and that is that we just learned, I think last week, or maybe early this week even, that Domino's is planning to ask the Supreme Court to take a look at this case. So we don't know yet if the Supreme Court is going to. We don't know what will happen, but definitely a case to keep an eye on. Okay, so now that we know that websites need to be accessible, the next question, of course, is, well, how do we do that? And I also just went through and told you that the ADA doesn't specifically mandate compliance with WCAG 2.0 or 2.1, but I'm also here to tell you that as a practical matter, the best advice that we have right now is to comply with WCAG 2.0 or 2.1. Why is that? Well, if you look at what's been required by the court so far, if you look at what's been invoked in both DOJ settlement agreements and private settlement agreements, essentially everyone is using WCAG 2.0 and more recently WCAG 2.1. So I'm going to go through a couple different examples. And the first is the Gill versus Winn-Dixie case. And this is a case where we have an individual who's blind who looked at the the website of a grocery store, Winn-Dixie, and was unable to access various components of the grocery store's website. So brought an ADA lawsuit, and this case actually went before a judge. It was a bench trial, and this was the first, and to my knowledge, the only case that has had an actual trial on the issue of website accessibility. And so the judge concluded that Winn-Dixie did, in fact, violate the ADA by not having an accessible website. And then as a remedy, as a kind of a, how are we going to make this right? How are we going to fix this? The court ordered Winn-Dixie to comply with WCAG 2.0 level AA. So we'll talk a little bit more about this case in a moment, but again, right now the only case we have where there has been a bench trial or trial on this issue has ordered compliance with WCAG 2.0. I will also say that this is another one of those cases that has been appealed. Winn-Dixie appealed this case, and that's pending before the 11th Circuit, and we've been waiting for a few months now for the 11th Circuit to issue its decision. So we'll see what happens there and if that changes anything. Slide 26. I just wanted to note that other courts are also kind of anxiously awaiting what happens in that Winn-Dixie case. So the next decision we have here is the Gomez versus GNC, the General Nutrition Corporation case. And here we have similar facts. We have somebody who's blind who brought a case against GNC for an inaccessible website. And here the plaintiff, Mr. Gomez, filed what's called a motion for summary judgment. So he asked the court to find as a matter of law that GNC violated the ADA. And the court did that. And they said, yes, there's, just from the information you've shown us, it is absolutely clear that GNC has violated the ADA by having an inaccessible website. And then the plaintiff also asked, okay, well, I'd like you to order compliance with WCAG 2.0 as a remedy. And the court kind of paused there and said, look, we're going to move forward to talk about the remedy. And I do think that the cases applying WCAG 2.0 are highly persuasive, but we're going to wait and see what happens with this Winn-Dixie appeal. So it's not just us that are waiting to see what happens. I think other courts are waiting to see what happens as well. But as I mentioned, in addition to the court decisions, we're also seeing both public and private settlements looking at WCAG 2.0. And so here we have a link just to the Department of Justice's Disability Rights Section's website, ada.gov. If you look there, you'll find a number of different settlement agreements about website accessibility, and they have all been using WCAG 2.0. And I would expect that as things continue, we'll see a move to WCAG 2.1. Moving on to slide 27. We have seen since the publication of WCAG 2.1 that there are some private settlement agreements that are starting to reference it. And I wanted to highlight two agreements, both that are just fantastic settlements on other points, but I wanted to kind of focus on the WCAG issue. So we've got the settlement agreement between the National Federation of the Blind and the County of Alameda. Here again, this is a broad settlement that talks about the accessibility of voting. So it looks at voting machines and vote by mail, but it also looks at the accessibility of the county's website, and it does require a compliance with WCAG 2.1. The same thing we see with the American Council of the Blind versus Hulu. I think most of us are familiar with Hulu, the online streaming service, and the American Council of the Blind brought a lawsuit because the content didn't include audio description. So again, a broad settlement that addresses all of those issues, but what's relevant to our purpose today is that that Hulu agreed to make its website comply with WCAG 2.1 level AA. And to have its mobile app comply with the standard called the BBC Mobile Accessibility Standards. So I wanted to highlight just to show you that even though WCAG 2.1 is a relatively new publication, it is starting to be used in the settlement agreements. Okay, well, making sure that we as businesses have accessible websites, it requires us to identify the standard we're going to use and what we're going to strive for. But to really ensure long-term success, we got to do more than that. And so what I've tried to do in the next few slides is look at some settlement agreements and some cases and pull out some of kind of the best strategies that we're seeing. And if you look at these agreements, a lot of them have a lot of the same language, but I'm just kind of highlighting a couple aspects of each of them. So again, on slide 28, some of the lessons that we've learned from various settlement agreements are that it's really important to draft and implement website accessibility policies. We all know policies are good. It's good to put things on paper about what we strive to do and then to figure out how best to implement that policy. And I always think it's a great practice when we're crafting our own policies, not to start from scratch. We don't have to be the first ones inventing the wheel here. There are tons of policies out there, both from settlement agreements and just other successful businesses. And so my recommendation would be to try to get your hands on some of those and learn from what other people have done. So as one example, I have the Department of Justice's agreement with H&R Block. This is a case that was initially brought by the National Federation of the Blind, and the Department of Justice intervened. It was one of the first comprehensive cases that DOJ got involved with about website accessibility, and it's at this point a little bit old. It's from 2014, but it's still a really nice broad policy that talks about, kind of hits on all the key points. And so if we look at that policy, we see that the policy, one, that they're going to have a policy, they're going to distribute that policy, and in that policy they're going to solicit feedback about how accessibility can be provided. They're going to publicize that. They're going to have a web accessibility coordinator. They're going to have annual training. They're going to have some automated tests to test for accessibility on a regular basis, both automated tests and enlisting actual people with disabilities to help do those tests, and to have a professional consultant to help evaluate the accessibility. So we have a link to that agreement at the bottom of this slide, and encourage you to take a look at that one if you're looking to work on your own policy. Slide 29. Another tip for ensuring long-term success is making sure that we think through everything that is on our website. So, website often incorporates third-party content. We use third-party vendors to help with, providing our map feature or providing other sorts of features. And what we've learned is that, we as public accommodations need to make sure that all of that content is accessible, even if we're relying on vendors or third parties to provide that content, because we're still the entity providing it. Other lessons are to make sure that we're having website audits on a regular basis and to have training on a regular basis. And these are all strategies that we see throughout various settlement agreements, but just to highlight one case that references it, we'll go back to the Gill versus Winn-Dixie case, which was the case where we had the trial. And here, the judge, in addition to requiring compliance with WCAG 2.0 level AA, actually ordered Winn-Dixie to have website audits every 3 months through an automated testing, required Winn-Dixie to have annual web training, and that was for all employees who write or develop programs or code for the website. And again, this is a kind of a key point here, to make sure that all third-party vendors are providing accessible content. And there's lots of different ways you can do that, by having agreements, by when a company initially enters into an agreement with third parties, having that conversation, by testing that information as well. But it's important to remember that that content is information you're relaying and needs to be accessible. Okay, slide 30. Another tip for long-term success is to ask for feedback and not just ask for it, but actually take action on that feedback. And this is something, you remember I just said it with the H&R Block, but it's a really good practice to put in place, and so I just wanted to highlight another settlement agreement where I like the language about asking for feedback, and that is a settlement agreement with Sweetgreen. And here, Sweetgreen is, of course, a restaurant that has customized salads, and they had an online portal and a mobile app where customers could place customized salad orders. But the technology wasn't accessible. So there's a settlement agreement that requires a whole host of things. It's really comprehensive, requires WCAG 2.0 training. But what I really liked in this is that it requires the website to have a specific link on its Contact Us page so that customers can give feedback about accessibility. And it makes it so that folks can give feedback through an accessible form. There's an email address, there's a telephone number, there's a TTY telephone number, and there's a requirement that within 30 days of receiving feedback, Sweetgreen's going to take reasonable steps towards remediation. So it's really, I think when organizations do this, they're telling their customers, hey, we want to make sure we're being accessible to you. Help us help you. And then by actually taking action on it, I think shows some real good faith. Slide 31. Another tip that we're seeing throughout the case law and throughout the settlement agreements is this idea of making sure we have the right folks doing this. This is technical stuff, and this isn't something that should just be added to somebody's plate. We really need to make sure we're hiring the right people and holding those people accountable. And so again, this was something I also mentioned with the H&R Block policy, but I wanted to highlight here the Project Civic Access Agreement. And this is, it's a Title II case. I know we're talking about it in the Title III section, but it's helpful. And this was actually the first web accessibility settlement in the new administration. And what the agreement says is that the City of Denver is going to maintain an employee as a web accessibility coordinator. So, of course, centralizing the process is really great. Training that person about how to conform the content and services. And then, this is what I think is really important, adding accessibility to the performance review of this employee. So man, doesn't that really make it clear that this is really important and we really value this because we're actually going to judge you as an employee about how well you do that. I thought that was a really kind of powerful statement. And then in addition to this internal person, there's a requirement that Denver is going to retain an independent consultant to evaluate the website and do annual evaluations. Okay, moving on, the next couple of slides are going to look at some things that we have not yet really talked about. So, so far we've really been focusing on folks who are blind and who use screen readers. And the reason for that is that the vast majority of cases about website accessibility are about folks who are blind who use screen readers. But that's not all we need to think about. We certainly need to think of people with other disabilities. And so I wanted to highlight this one case that's pending right now, the National Association of the Deaf versus Harvard, and there's a companion case, the National Association of the Deaf versus MIT. And in these cases, both Harvard and MIT had this online learning platform, and they offered all sorts of really exciting online learning opportunities. Folks could learn about arts and literature and engineering, but they offered all of this information both through audio and audio-visual content. And guess what? No captioning. So people who are deaf or hard of hearing weren't able to access it. So both Harvard and MIT filed a motion to dismiss or a motion to stay, kind of arguing that same thing, like let's wait for the Department of Justice's technical expertise. And the court back in 2016 found for the plaintiffs on that. They said there's no need to wait for the Department of Justice's technical expertise. We know DOJ's position. It didn't hurt that in this case, DOJ actually filed a statement of interest explaining what its position was. And they also kind of rejected the arguments at this point on a motion to dismiss that it would be an undue burden or a fundamental alteration to have online content captioned. So, this is an exciting case to keep watching. The parties are still working through this case, but a good reminder that we got to make sure we're considering needs of people with diverse disabilities. Another good reminder on slide 33 is that, again, to date we've talked mostly about websites, but digital accessibility extends beyond that. So you got to think about things like kiosks and point-of-sales devices. A kiosk, there's so many so many times where we all use kiosks to check into places and other sorts of things like that. And so an example here of an accessible kiosk was a case that was brought and settled in 2014 against Redbox. Folks may remember Redbox is where you go to that self-service station and you can actually put in some information and then you get to take a DVD. But, the whole thing wasn't accessible to folks who are blind. And so Redbox agreed to make its kiosk accessible by adding kind of a standard headphone jack, adding a tactile keyboard, and adding a text-to-speech output for all of its Redbox video rental kiosks in California. In addition to kiosks, we also need to think about point-of-sale devices. Those are, of course, the little machines that we use when we're checking out at a store and we put in our credit card information. Well, think about the folks who aren't able to access that keypad and then might have to disclose their PIN number to the salesperson. So it's important to remember point-of-sale devices and try to make those accessible as well. And we have a link here to an agreement from 2015 with a grocery store called Rally's, where Rally's agreed to add tactile PIN pads to enable people to access those point-of-sale devices privately and independently. Slide 34. And finally, again, most of what we've talked about today has been in the Title III context, since this is our Title III session. But I do want to just remind everyone that digital access can be really important for our employees and our applicants as well. A key point is to make sure that all of your online applications are accessible. And a tip is that, it's better not to wait until you have an applicant or employee who needs the access, because as we all know, it's cheaper and easier to make things accessible from the start than to try to retrofit it. The next slide, slide 35, I have one case example. It's the Martinez versus Alorca case. And here we have an individual who's blind who wanted to be able to apply for a job, but he couldn't because the online application wasn't accessible. And so he reached out through his attorney to request that these barriers be removed, but the company never responded. And so he brought a lawsuit under California State Court arguing, that there was a failure to make a reasonable accommodation. And this case, it seems as if this case is settled, but it reminds us that we need to think about website access and digital access more broadly as well. Slide 36, I've got a bunch of resources for you. I'm putting a shout out to Leni Feingold, who has a number of wonderful resources on her website. She has a list of accessibility consultants, usability testing. I encourage you to check those out. And just as a caution, no online tool is perfect. It's a first step only. To do a true assessment, we do need to get real people testing it as well. And of course, the ADA National Network provides some information about accessibility too. So quick recap of the lessons learned. Remember, even though DOJ hasn't issued regs, businesses and other entities have an obligation to comply with the ADA. Although the ADA doesn't specifically mandate compliance with WCAG 2.0 or 2.1, as a practical matter, at least at this point, that's what folks should be using. We want to create policies to require accessibility of third-party vendors, conduct website audits on a regular basis, conduct training on a regular basis, make sure that we have website accessibility policies, and use others to learn from. Slide 38, we want to ask for feedback from the disability community, and we want to act on that feedback. We want to hire the right people and hold those people accountable. Let's remember the needs of people with various disabilities. Let's remember issues beyond websites, and let's especially remember those applicants and employees.
Rachel, if you can hear me, uncheck your talk button and press it again, please. We are now on slide 39, and Caleb, you can announce Rachel's contact information.
Okay. Sorry we lost her there right at the end. So on the slide we have her contact info. So you can contact Rachel at 312-895-7319. And her email address is rachelweisberg@equipforequality.org. So I want to thank Rachel for doing this series for us. There's been a lot of great information here, and we really appreciate her efforts. On slide 40, if you have any questions about the Americans with Disabilities Act, you can contact the ADA National Network at 800-949-4232. And their website is adata.org. Lots of good info on there. You can contact us if you're within our region at 301-217-0124. And our website is adainfo.org. And if you have questions about training, you can send us an email at adatraining@transcend.org. Slide 41. So for upcoming trainings and webinars, you can check out our training section on adainfo.org, and you can also look at the event section at adata.org. Slide 42. So thank you everyone for joining us, and hope you have a great day.